Hello, everyone. Today's case is Shelby County, Alabama v. Holder. So, this is regarding the Voting Rights Act. The Voting Rights Act of 1965 was enacted to address entrenched racial discrimination in voting, an insidious and pervasive evil which had been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. Section 2 of the Act, which bans any standard, practice, or procedure that results in a denial or abridgment of the right of any citizen to vote on account of race or color, applies nationwide, is permanent, and is not at issue in this case. Other sections apply only to some parts of the country. Section 4 of the Act provides the coverage formula, defining the covered jurisdictions as states or political subdivisions that maintain tests or devices as prerequisites to voting and had low voter registration or turnout in the 1960s and early 1970s. In those covered jurisdictions, subsection 5 of the Act provides that no change in voting procedures shall take where was I? In those covered jurisdictions, subsection 5 of the Act provides that no change in voting procedures can take effect until approved by specific federal authorities in Washington, D.C. Such approval was known as preclearance. The coverage formula and preclearance requirement were initially set to expire after 5 years, but the Act has been reauthorized several times. In 2006, the Act was reauthorized for an additional 25 years, but the coverage formula was not changed. Coverage still turned on whether a jurisdiction had a voting test in the 1960s or 1970s and had low voter registration or turnout at that time. Shortly after the 2006 reauthorization, a Texas utility district sought to bail out from the Act's coverage and, in the alternative, challenged the Act's constitutionality. This court resolved the challenge on statutory grounds, but expressed serious doubts about the Act's continued constitutionality. Petitioner Shelby County, in the covered jurisdiction of Alabama, sued the Attorney General in federal district court in Washington, D.C., seeking a declaratory judgment that subsection 4B and subsection 5 are facially unconstitutional, as well as a permanent injunction against their enforcement. The district court upheld the act, finding that the evidence before Congress in 2006 was sufficient to justify reauthorizing subsection 5 and continuing subsection 4B's coverage formula. The D.C. Circuit affirmed. After surveying the evidence in the record, the court accepted Congress's conclusion that subsection 2 litigation remained inadequate in the covered jurisdictions to protect the rights of minority voters, that subsection 5 was therefore still necessary, and that the coverage formula continued to pass constitutional muster. Held. Section 4 of the Voting Rights Act is unconstitutional. Its formula can no longer be used as a basis for subjecting jurisdictions to preclearance. In Northwest Austin, this court noted that the Voting Rights Act imposed current burdens that must be justified by current needs, and concluded that a departure from the fundamental principle of equal sovereignty requires a showing that a statute's disparate geographic coverage is sufficiently related to the problem that it targets. These basic principles guide review of the question presented here. State legislation may not contravene federal law. States retain broad autonomy, however, in structuring their governments in pursuing legislative objectives. Indeed, the 10th Amendment reserves to the states all powers not specifically granted to the federal government, including the power to regulate elections. There is also a fundamental principle of equal sovereignty among the states, which is highly pertinent in assessing disparate treatment of states. The Voting Rights Act sharply departs from these basic principles. It requires states to beseech the federal government for permission to implement laws that they would otherwise have the right to enact and execute on their own. And despite the tradition of equal sovereignty, the act applies to only 9 states and additional counties. That is why in 1966 this court described the act as stringent and potent. The court nonetheless upheld the act, concluding that such an uncommon exercise of congressional power could be justified by exceptional conditions. In 1966, these departures were justified by the blight of racial discrimination in voting that had infected the electoral process in parts of our country for nearly a century. At the time, the coverage formula, the means of linking the exercise of the unprecedented authority with the problem that warranted it, made sense. The act was limited to areas where Congress found evidence of actual voting discrimination, and the covered jurisdictions shared two characteristics: the use of these tests and devices for voter registration, and a voting rate in the 1964 presidential election at least 12 points below the national average. The court explained that tests and devices are relevant to voting discrimination because of their long history as a tool for perpetrating the evil. A low voting rate is pertinent for the obvious reason that widespread disenfranchisement must inevitably affect the number of actual voters. The court therefore concluded that the coverage formula was rational in both practice and theory. Nearly 50 years later, things have changed dramatically. Largely because of the Voting Rights Act, voter turnout and registration rates in covered jurisdiction now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. The tests and devices that block ballot access have been forbidden nationwide for over 40 years. Yet the Act has not eased Subsection 5's restrictions or narrowed the scope of Subsection 4's coverage formula along the way. Instead, those extraordinary and unprecedented features have been reauthorized as if nothing had changed, as if nothing has changed, and they have grown even stronger. Because subsection 5 applies only to those jurisdictions singled out by subsection 4, the court turns to consider that provision. Section 4's formula is unconstitutional in light of current conditions. In 1966, the coverage formula was rational in both practice and theory. It looked to cause discriminatory tests and affect low voter registration and turnout, and tailored the remedy preclearance to those jurisdictions exhibiting both. By 2009, however, the coverage formula raised serious constitutional questions. Coverage today is based on decades-old data and eradicated practices. The formula captures states by reference to literacy tests and low voter registration and turnout in the 1960s and early 1970s. But such tests have been banned for over 40 years, and voter registration and turnout numbers in covered states have risen dramatically. In 1965, the states could be divided into those with a recent history of voting tests and low voter registration and turnout, and those without those characteristics. Congress based its coverage formula on that distinction. Today, the nation is no longer divided along those lines, yet the Voting Rights Act continues to treat it as if it were. The government attempts to defend the formula on grounds that it is reverse engineered. Congress identified the jurisdictions to be covered and then came up with criteria to describe them. Katzenbach did not sanction such an approach, reasoning instead that the coverage formula was rational because the formula was relevant to the problem. The government had the government has a fallback argument. Because the formula was relevant in 1965, its continued use is permissible so long as any discrimination remains in the states identified in 1965. But this does not look to current political conditions, instead relying on a comparison between the states in 1965. But history did not end in 1965. In assessing the current need for a preclearance system treating states differently from one another today, history since 1965 cannot be ignored. The 15th Amendment is not designed to punish for the past. Its purpose is to ensure a better future. To serve that purpose, Congress, if it is to divide the states, must identify those jurisdictions to be singled out on a basis that makes sense in light of current conditions. Respondents also rely heavily on data from the record compiled by Congress before reauthorizing the Act. Regardless of how one looks at that record, no one can fairly say that it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that clearly distinguished the covered jurisdictions from the rest of the nation in 1965. But a more fundamental problem remains. Congress did not use that record to fashion a coverage formula grounded in current conditions. It instead reenacted a formula based on 40-year-old facts having no logical relation to the present day. Chief Justice Roberts delivered the opinion of the court, in which Scalia, Kennedy, Thomas, and Alito joined. Thomas filed a concurring opinion. Ginsburg filed a dissenting opinion, in which Breyer, Sotomayor, and Kagan joined. Chief Justice Roberts delivered the opinion of the court. The Voting Rights Act of 1965 employed extraordinary measures to address an extraordinary problem. Section 5 of the Act required states to obtain federal permission before enacting any law related to voting, a drastic departure from basic principles of federalism, and subsection 4 of the Act applied to that requirement only to some states, an equally dramatic departure from the principle that all states enjoy equal sovereignty. This was strong medicine, but Congress determined it was needed to address entrenched racial discrimination in voting, an insidious and pervasive evil which had been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. As we explain in upholding the law, exceptional conditions can justify legislative measures not otherwise appropriate. Reflecting the unprecedented nature of these measures, they were scheduled to expire after 5 years. Nearly 50 years later, they are still in effect. Indeed, they have been made more stringent and are now scheduled to last until 2031. There is no denying, however, that the conditions that originally justified these measures no longer characterize voting in the covered jurisdictions. By 2009, the racial gap in voter registration and turnout was lower in the states originally covered by subsection 5 than it was nationwide. Since that time, Census Bureau data indicate that African American voter turnout has come to exceed white voter turnout in 5 of the 6 states originally covered by subsection 5, with a gap in the sixth state of less than one half of 1%. At the same time, voting discrimination still exists. No one doubts that. The question is whether the Act's extraordinary measures, including its disparate treatment of the states, continue to satisfy constitutional requirements. As we put it a short time ago, the Act imposes current burdens that must be justified by current needs. The 15th Amendment was ratified in 1870 in the wake of the Civil War. It provides that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, and it gives Congress the power to enforce this article by appropriate legislation. The first century of congressional enforcement of the amendment, however, can only be regarded as a failure. In the 1890s, Alabama, Georgia, Louisiana, Mississippi, North Carolina, South Carolina, and Virginia began to enact literacy tests for voter registration and to employ other methods designed to prevent African Americans from voting. Congress passed statutes outlawing some of these practices and facilitating litigation against them. The litigation remained slow and expensive, and the states came up with new ways to discriminate as soon as existing ones were struck down. The voter registration of African Americans barely improved. Inspired to action by the Civil Rights Movement, Congress responded in 1965 with the Voting Rights Act. Section 2 was enacted to forbid in all 50 states any standard, practice, or procedure imposed or applied to deny or abridge the right of any citizen of the United States to vote on account of race or color. The current version forbids any state, practice, or procedure that results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. Both the federal government and individuals have sued to enforce subsection 2, and injunctive relief is available in appropriate cases to block voting laws from going into effect. Section 2 is permanent, applies nationwide, and is not at issue in this case. Other sections targeted only some parts of the country. At the time of the Act's passage, these covered jurisdictions were those states or political subdivisions that had maintained a test or device as a prerequisite to voting as of November 1st, 1964, and had less than 50% voter registration or turnout in the 1964 presidential election. Such tests or devices included literacy and knowledge tests, good moral character requirements, the need for vouchers from registered voters, and the like. A covered jurisdiction could bail out of coverage if it had not used a test or device in the preceding 5 years for the purpose or with the effect of denying or abridging the right to vote on account of race or color. In 1965, the covered states included Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. The additional covered subdivisions included 39 counties in North Carolina and one in Arizona. In those jurisdictions, subsection 4 of the Act banned all such tests or devices. Section 5 provided that no change in voting procedures could take effect until it was approved by federal authorities in Washington, D.C., either the Attorney General or a court of 3 judges. A jurisdiction could obtain such preclearance only by proving that the change had neither the purpose nor the effect of denying or abridging the right to vote on account of race or color. Section 4 and 5 were intended to be temporary. They were set to expire after 5 years. In South Carolina v. Katzenbach, we upheld the 1965 Act against constitutional challenge, explaining that it was justified to address voting discrimination where it persists on a pervasive scale. In 1970, Congress reauthorized the Act for another 5 years and extended the coverage formula in subsection 4B to jurisdictions that had a voting test and less than 50% voter registration or turnout as of 1968. The Voting Rights Act the Voting Rights Act amendments of 1970, subsections 3 and 4, uh, that swept in several counties in California, New Hampshire, and New York. Congress also extended the ban in subsection 4A on tests and devices nationwide. In 1975, Congress reauthorized the Act for 7 more years and extended its coverage to jurisdictions that had a voting test and less than 50% voter registration or turnout as of 1972. Voting Rights Act amendments of 1975, subsections 101, 202, 89, stat 400, and 401. Congress also amended the definition of test or device to include the practice of providing English-only voting materials in places where over 5% of voting-age citizens spoke a single language other than English. As a result of these amendments, the states of Alaska, Arizona, and Texas, as well as several counties in California, Florida, Michigan, New York, North Carolina, and South Dakota, became covered jurisdictions. Congress correspondingly amended subsection 2 and subsection 5 to forbid voting discrimination on the basis of membership in a language minority group, in addition to discrimination on the basis of race or color. Finally, Congress made the nationwide ban on tests and devices permanent. In 1982, Congress reauthorized the Act for 25 years but did not alter its coverage formula. Congress did, however, amend the bailout provision, allowing political subdivisions of covered jurisdictions to bail out. Among other prerequisites for bailout, jurisdictions and their subdivisions must not have used a forbidden test or device, failed to receive preclearance, or lost a subsection 2 suit in the 10 years prior to seeking bailout. We upheld each of these reauthorizations against constitutional challenge. In 2006, Congress again reauthorized the Voting Rights Act for 25 years, again without change to its coverage formula. Congress also amended subsection 5 to prohibit more conduct than before. Section 5 now forbids voting changes with any discriminatory purpose, as well as voting changes that diminish the ability of citizens on account of race, color, or language minority status to elect their preferred candidates of choice. Shortly after this authorization, a Texas utility district brought suit seeking to bail out from the Act's coverage, and, in the alternative, challenging the Act's constitutionality. A three-judge district court explained that only a state or political subdivision was eligible to seek bailout under the statute and concluded that the utility district was not a political subdivision, a term that encompasses only counties, parishes, and voter registration subunits. The district court also rejected the constitutional challenge. We reverse. We explain that normally the court will not decide a constitutional question if there is some other ground upon which to dispose of the case, concluding that underlying constitutional concerns, among other things, compelled a broader reading of the bailout provision. Concluding that underlying constitutional concerns, among other things, compelled a broader reading of the bailout provision, we construed the statute to allow the utility districts to seek bailout. In doing so, we expressed serious doubts about the Act's continued constitutionality. We explained that subsection 5 imposes substantial federalism costs and differentiates between the states despite our historic tradition that all the states enjoy equal sovereignty. We also noted that things have changed in the South. Voter turnout and registration rates now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. Finally, we questioned whether the problems that subsection 5 meant to address were still concentrated in the jurisdictions singled out for preclearance. 8 members of the court subscribed to these views, and the remaining member would have held the act unconstitutional. Ultimately, however, the court's construction of the bailout provision left the constitutional issues for another day. Shelby County is located in Alabama, a covered jurisdiction. It has not sought bailout, as the Attorney General has recently objected to voting changes proposed from within the county. Instead, in 2010, the county sued the Attorney General in federal district court in Washington, D.C., seeking a declaratory judgment that subsection 4B and 5 of the Voting Rights Act are facially unconstitutional, as well as a permanent injunction against their enforcement. The district court ruled against the county and upheld the act. The court found that the evidence before Congress in 2006 was sufficient to justify reauthorizing subsection 5 and continuing the subsection 4B coverage formula. The Court of Appeals of the D.C. Circuit affirmed. In assessing subsection 5, the D.C. Circuit considered 6 primary categories of evidence: Attorney General objections to voting changes, Attorney General requests for more information regarding voting changes, successful subsection 2 suits in covered jurisdictions, the dispatching of federal observers to monitor elections in covered jurisdictions, subsection 5 preclearance suits involving covered jurisdictions, and the deterrent effect of subsection 5. After extensive analysis of the record, the court accepted Congress's conclusion that subsection 2 litigation remained inadequate in the covered jurisdictions to protect the rights of minority voters, and that subsection 5 was therefore still necessary. Turning to subsection 4, the D.C. Circuit noted that the evidence for singling out the covered jurisdictions was less robust and that the issue presented a close question. But the court looked to data comparing the number of successful subsection 2 suits in the different parts of the country. Coupling that evidence with the deterrent effect of subsection 5, the court concluded that the statute continued to single out the jurisdictions in which discrimination is concentrated, and thus held that the coverage formula passed constitutional muster. Judge Williams dissented. He found no positive correlation between inclusion in subsection 4B's coverage formula and low black registration or turnout. Rather, to the extent there was any correlation, it actually went the other way. Condemnation under subsection 4B is a marker of higher black registration and turnout. Judge Williams also found that covered jurisdictions have far more black office holders as a proportion of the black population than do uncovered ones. And to the evidence of successful subsection 2 suits, Judge Williams disaggregated the reported cases by state and concluded that the 5 worst uncovered jurisdictions have worse records than 8 of the covered jurisdictions. He also noted that 2 covered jurisdictions, Arizona and Alaska, had not had any successful reported subsection 2 suit brought against them during the entire 24 years covered by the data. Judge Williams would have held the coverage formula of subsection 4B irrational and unconstitutional. We granted certiorari. In Northwest Austin, we stated that the Act imposes current burdens that must be justified by current needs. And we concluded that a departure from the fundamental principle of equal sovereignty requires a showing that a statute's disparate geographic coverage is sufficiently related to the problem that it targets. These basic principles guide our review of the question before us. The Constitution and laws of the United States are the supreme law of the land. State legislation may not contravene federal law. The federal government does not, however, have a general right to review and veto state enactments before they go into effect. A proposal to grant such authority to negative state laws was considered at the Constitutional Convention, but rejected in favor of allowing state laws to take effect, subject to later challenge under the Supremacy Clause. Outside the strictures of the Supremacy Clause, states retain broad autonomy in structuring their governments and pursuing legislative objectives. Indeed, the Constitution provides that all powers not specifically granted to the federal government are reserved to the states or citizens. This allocation of powers in our federal system preserves the integrity, dignity, and residual sovereignty of the states. But the federal balance is not just an end in itself. Rather, federalism secures to citizens the liberties that derive from the diffusion of sovereign power. More specifically, the framers of the Constitution intended the states to keep for themselves, as provided in the 10th Amendment, the power to regulate elections. Of course, the federal government retains significant control over federal elections. For instance, the Constitution authorizes Congress to establish the time and manner for electing senators and representatives. but states have broad power to determine the conditions under which the right of suffrage may be exercised. And each state has the power to prescribe the qualifications of its officers and the manner in which they shall be chosen. Drawing lines from congressional districts is likewise primarily the duty and responsibility of the state. Not only do states retain sovereignty under the Constitution, there is also a fundamental principle of equal sovereignty among the states. Over 100 years ago, this court explained that our nation was and is a union of states equal in power, dignity, and authority. Indeed, the constitutional equality of the states is essential to the harmonious operation of the scheme upon which the republic was organized. Coyle concerned the admission of new states, and Katzenbach rejected the notion that the principle operated as a bar on different treatment outside that context. At the same time, we made clear in Northwest Austin the fundamental principle of equal sovereignty remains highly pertinent in assessing subsequent disparate treatment of states. The Voting Rights Act sharply departs from these basic principles. It suspends all changes to state election law, however innocuous, until they have been pre-cleared by federal authorities in Washington, D.C. States must beseech the federal government for permission to implement laws that they would otherwise have the right to enact and execute on their own, subject, of course, to any injunction in a subsection 2 action. The Attorney General has 60 days to object to a preclearance request, longer if he requests more information. If a state seeks preclearance from a three-judge court, the process can take years. And despite the tradition of equal sovereignty, the act applies to only 9 states and several additional counties. While one state waits months or years and expends funds to implement a validly enacted law, its neighbor can typically put the same law into effect immediately through the normal legislative process, even if a non-covered jurisdiction is sued. There are important differences between those proceedings and preclearance proceedings. The preclearance proceeding not only switches the burden of proof to the supplicant jurisdiction, but also applies substantive standards quite different from those governing the rest of the nation. All this explains why, when we first upheld the act in 1966, we described it as stringent and potent. We recognized that it may have been an uncommon exercise of congressional power, but concluded that legislative measures not otherwise appropriate could be justified by exceptional conditions. We have since noted that the Act authorizes federal intrusion into sensitive areas of state and local policymaking and represents an extraordinary departure from the traditional course of relations between the states and the federal government. As we reiterated in Northwest Austin, the Act constitutes extraordinary legislation otherwise unfamiliar to our federal system. In 1966, we found these departures from the basic features of our system of government justified. The blight of racial discrimination in voting had infected the electoral process in parts of our country for nearly a century. Several states had enacted a variety of requirements and tests specifically designed to prevent African Americans from voting. Case by case litigation had proved inadequate to prevent such racial discrimination in voting, in part because states merely switched to discriminatory devices not covered by the federal decrees, enacted difficult new tests, or simply defied and evaded court orders. Shortly before enactment of the Voting Rights Act, only 19.4% of African Americans of voting age were registered to vote in Alabama, only 31.8% in Louisiana, and only 6.4% in Mississippi. Those figures were roughly 50 percentage points or more below the figures for whites. In short, we concluded that under the compulsion of these unique circumstances, Congress responded in a permissibly decisive manner. We also noted then, and have emphasized since, that this extraordinary legislation was intended to be temporary, set to expire after 5 years. At the time, the coverage formula, the means of linking the exercise of the unprecedented authority with the problem that warranted it, made sense. We found that Congress chose to limit its attention to the geographic areas where immediate action seemed necessary. The areas where Congress found evidence of actual voting discrimination shared 2 characteristics: the use of voting tests, the use of tests and devices for voter registration, and a voting rate in the 1964 presidential election at least 12 points below the national average. We explained that tests and devices are relevant to voting discrimination because of their long history as a tool for perpetrating the evil. A low voting rate is pertinent for the obvious reason that widespread disenfranchisement must inevitably affect the number of actual voters. We therefore concluded that the coverage formula was rational in both practice and theory. It accurately reflected those jurisdictions uniquely characterized by voting discrimination on a pervasive scale, linking coverage to the devices used to effectuate discrimination and to the resulting disenfranchisement. The formula ensured that the stringent remedies were aimed at areas where voting discrimination had been most flagrant. Nearly 50 years later, things have changed dramatically. Shelby County contends that the pre-clearance requirement, even without regard to its disparate coverage, is now unconstitutional. Its arguments have a good deal of force. In the covered jurisdictions, voter turnout and registration rates now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. The tests and devices that blocked access to the ballot have been forbidden nationwide for over 40 years. Those conclusions are not ours alone. Congress said the same when it reauthorized the Act in 2006, writing that significant progress has been made in eliminating first generation barriers experienced by minority voters, including increased numbers of registered minority voters, minority voter turnout, and minority representation in Congress. State legislatures and local elected officials, state legislatures and local elected officials, offices. The House report elaborated that the number of African Americans who are registered and who turn out to cast ballots has increased significantly over the last 40 years, particularly since 1982, and noted that in some circumstances, minorities register to vote and cast ballots at levels that surpass those of white voters. That report also explained that there have been significant increases in the number of African Americans serving in elected offices. More specifically, there have been approximately a 1,000% increase since 1965 in the number of African American elected officials in the 6 states originally covered by the Voting Rights Act. The following chart, compiled from the Senate and House reports, compares voter registration numbers from 1965 to those from 2004 in the 6 originally covered states. These are the numbers that were before Congress when it reauthorized the Act in 2006. The 2004 figures come from the Census Bureau. The Census Bureau data from the most recent election indicate that African American voter turnout exceeded white voter turnout in 5 of the 6 states originally covered by subsection 5, with a gap in the 6th state of less than one half of 1%. The pre-clearance statistics are also illuminating. In the first decade after enactment of subsection 5, the Attorney General objected to 14.2% of proposed voting changes. In the last decade before reenactment, the Attorney General objected to a mere 0.16%. There is no doubt that these improvements are in large part because of the Voting Rights Act. The Act has proved immensely successful at redressing racial discrimination and integrating the voting process. During the Freedom Summer of 1964 in Philadelphia, Mississippi, 3 men were murdered while working in the area to register African American voters. On Bloody Sunday in 1965 in Selma, Alabama, police beat and used tear gas against hundreds marching in support of African American enfranchisement. Today, both of those towns are governed by African American mayors. Problems remain in these states and others, but there is no denying that due to the Voting Rights Act, our nation has made great strides. Yet the Act has not eased the restrictions in subsection 5 or narrowed the scope of the coverage formula in subsection 4b along the way. Those extraordinary and unprecedented features were reauthorized as if nothing had changed. In fact, the Act's unusual remedies have grown even stronger. When Congress reauthorized the Act in 2006, it did so for another 25 years on top of the previous 40, a far cry from the initial 5-year period. Congress also expanded the prohibitions in subsection 5. We had previously interpreted subsection 5 to prohibit only those redistricting plans that would have the purpose of effect or worsen that would have the purpose or effect of worsening the position of minority groups. In 2006, Congress amended subsection 5 to protect laws that could have favored such groups, but did not do so because of a discriminatory purpose. Even though we had stated that such broadening of subsection 5 coverage would exacerbate the substantial federalism costs that the pre-clearance procedure already exacts, perhaps to the extent of raising concerns about subsection 5's constitutionality. In addition, Congress expanded subsection 5 to prohibit any voting law that has the purpose of or will have the effect of diminishing the ability of any citizens of the United States on account of race, color, or language minority status to elect their preferred candidates of choice. In light of those two amendments, the bar that covered jurisdictions must clear has been raised even as the conditions justifying that requirement have dramatically improved. We have also previously highlighted the concern that the preclearance requirements in one state might be unconstitutional in another. Nothing has happened since to alleviate this troubling concern about the current application of subsection 5. Respondents do not deny that there have been improvements on the ground, but argue that much of this can be attributed to the deterrent effect of subsection 5, which dissuades covered jurisdictions from engaging in discrimination that they would resume should subsection 5 be struck down. Under this theory, however, subsection 5 would be effectively immune from scrutiny, no matter how clean the record of covered jurisdictions. The argument could always be made that it was deterrence that accounted for the good behavior. The provisions of subsection 5 apply only to those jurisdictions singled out by subsection 4. We now consider whether that coverage formula is constitutional in light of current conditions. When upholding the constitutionality of the coverage formula in 1966, we concluded that it was rational in both practice and theory. The formula looked to cause discriminatory tests and affect low voter registration and turnout, and tailored the remedy preclearance to those jurisdictions exhibiting both. By 2009, however, we concluded that the coverage formula raised serious constitutional questions. As we explained, a statute's current burdens must be justified by current needs, and any disparate geographic coverage must be sufficiently related to the problem that it targets. The coverage formula met that test in 1965, but no longer does so. Coverage today is based on decades-old data and eradicated practices. The formula captures states by reference to literacy tests and low voter registration and turnout in the 1960s and early 1970s, but such tests have been banned nationwide for over 40 years. And voter registration and turnout numbers in the covered states have risen dramatically in the years since. Racial disparity in those numbers was compelling evidence justifying the preclearance remedy and the coverage formula. There is no longer such a disparity. In 1965, the states could be divided into two groups: those with a recent history of voting tests and low voter registration and turnout, and those without those characteristics. Congress based its coverage formula on that distinction. Today, the nation is no longer divided along these lines, yet the Voting Rights Act continues to treat them as if they were. The government's defense of the formula is limited. First, the government contends that the formula is reverse engineered. Congress identified the jurisdictions to be covered and then came up with criteria to describe them. Under that reasoning, there need not be any logical relationship between the criteria in the formula and the reason for coverage. All that is necessary is that the formula happened to capture the jurisdiction Congress wanted to single out. The government suggests that Katzenbach sanctioned such an approach, but the analysis in Katzenbach was quite different. Katzenbach reasoned that the coverage formula was rational because the formula was relevant to the problem. Tests and devices are relevant to voting discrimination because of their long history as a tool for perpetrating the evil. A low voting rate is pertinent for the obvious reason that widespread disenfranchisement must inevitably affect the number of actual voters. Here, by contrast, the government's reverse engineered argument does not even attempt to demonstrate the continued relevance of the formula to the problem it targets. And in the context of a decision as significant as this one, subjecting a disfavored subset of states to extraordinary legislation otherwise unfamiliar to our federal system. That failure to establish even relevance is fatal. The government falls back to the argument that because the formula was relevant in 1965, its continued use is permissible so long as any discrimination remains in the states Congress identified back then, regardless of how that discrimination compares to discrimination in states unburdened by coverage. This argument does not look to current political conditions, but instead relies on the comparison between the states in 1965. That comparison reflected the different histories of the North and South. It was in the South that slavery was upheld by law until uprooted by the Civil War, that the reign of Jim Crow denied African Americans the most basic freedoms, and that state and local governments worked tirelessly to disenfranchise citizens on the basis of race. The court invoked that history, rightly so, in sustaining the disparate coverage of the Voting Rights Act in 1966. But history did not end in 1965. By the time the act was reauthorized in 2006, there had been 40 more years of it. In assessing the current need for a pre-clearance system that treats states differently from one another today, that history cannot be ignored. During that time, largely because of the Voting Rights Act, voting tests were abolished, disparities in voter registration and turnout due to race were erased, and African Americans attained political office in record numbers. And yet, the coverage formula that Congress reauthorized in 2006 ignores these developments, keeping the focus on decades old data relevant to decades old problems, rather than current data reflecting current needs. The 15th Amendment commands that the right to vote shall not be denied or abridged on account of race or color, and it gives Congress the power to enforce that command. The amendment is not designed to punish for the past, its purpose is to ensure a better future. To serve that purpose, Congress, if it is to divide the states, must identify those jurisdictions to be singled out on a basis that makes sense in light of current conditions. It cannot rely simply on the past. We made that clear in Northwest Austin, and we continue to make it clear again today. In defending the coverage formula, the government, the interveners, and the dissent also rely heavily on data from the record that they claim justified disparate coverage. Congress compiled thousands of pages of evidence before reauthorizing the Voting Rights Act. The court below and the parties have debated what the record shows. They have gone back and forth about whether to compare covered to non-covered jurisdictions as blocks, how to disaggregate the data state by state, how to weigh subsection 2 cases as evidence of ongoing discrimination, and whether to consider evidence not before Congress, among other issues. Regardless of how to look at the record, however, no one can fairly say that it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that faced Congress in 1965, and that clearly distinguished the covered jurisdictions from the rest of the nation at the time. But a more fundamental problem remains. Congress did not use the record it compiled to shape a coverage formula grounded in current conditions. It instead reenacted a formula based on 40-year-old facts having no logical relation to the present day. The dissent relies on second-generation barriers, which are not impediments to the casting of ballots, but rather electoral arrangements that affect the weight of minority voters. That does not cure the problem. Viewing the pre-clearance requirements as targeting such efforts simply highlights the irrationality of continued reliance on the subsection 4 coverage formula, which is based on voting tests and access to the ballot, not vote dilution. We cannot pretend that we are reviewing an updated statute or try our hand at updating the statute ourselves, based on the new record compiled by Congress. Contrary to the dissent's contention, we are not ignoring the record. We are simply recognizing that it played no role in shaping the statutory formula before us today. The dissent also turns to the record to argue that, in light of voting discrimination in Shelby County, the county cannot complain about the provisions that subject it to preclearance. But that is like saying that a driver pulled over pursuant to a policy of stopping all redheads cannot complain about that policy if it turns out his license has expired. Shelby County's claim is that the coverage formula here is unconstitutional in all its applications because of how it selects the jurisdictions subjected to preclearance. The county was selected based on that formula and may challenge it in court. The dissent proceeds from a flawed premise. It quotes the famous sentence from McCulloch v. Maryland with the following emphasis: "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution, are constitutional." But this case is about a part of the sentence that the dissent does not emphasize. The part that asks whether a legislative means is consistent with the letter and spirit of the Constitution. The dissent states that it cannot be tenably maintained that this is an issue with regard to the Voting Rights Act. But 4 years ago, in an opinion joined by two of today's dissenters, the court expressly stated that the Act's preclearance requirements and its coverage formula raise serious constitutional questions. The dissent does not explain how those serious constitutional questions became untenable in 4 short years. The dissent treats the act as if it were just like any other piece of legislation. But this court has made clear from the beginning that the Voting Rights Act is far from ordinary. At the risk of repetition, Katzenbach indicated that the act was uncommon and not otherwise appropriate, but was justified by exceptional and unique conditions. Multiple decisions since have reaffirmed the act's extraordinary nature. Yet the dissent goes as far as to suggest that instead of that the preclearance requirement and disparate treatment of the states should be upheld into the future unless there is no or almost no evidence of unconstitutional action by states. In other ways as well, the dissent analyzes the question presented as if our decision in Northwest Austin never happened. For example, the dissent refuses to consider that the principle of equal sovereignty, despite Northwest Austin's emphasis on its significance. Northwest Austin also emphasized the dramatic progress since 1965, but the dissent describes the current levels of discrimination as flagrant, widespread, and pervasive. Despite the fact that Northwest Austin requires the enact disparate geographic coverage to be sufficiently related to its targeted problems, the dissent maintains that an act's limited coverage actually eases Congress's burdens, and suggests that a fortuitous relationship should suffice. Although Northwest Austin stated definitively that current burdens must be justified by current needs, the dissent argues that the coverage formula can be justified by history, and that the required showing can be weaker on reenactment than when the law was first passed. There is no valid reason to insulate the coverage formula from review merely because it was previously enacted 40 years ago. If Congress had started from scratch in 2006, it plainly could not have enacted the present coverage formula. It would have been irrational for Congress to distinguish between states in such a fundamental way based on 40-year-old data, when today's statistics tell an entirely different story. And it would have been irrational to base coverage on the use of voting tests 40 years ago, when such tests have been illegal since that time. But that is exactly what Congress has done. Striking down an act of Congress is the gravest and most delicate duty that this court is called on to perform. We do not do it lightly. That is why in 2009, we took care to avoid ruling on the constitutionality of the Voting Rights Act when asked to do so, and instead resolved the case then before us on statutory grounds. But in issuing that decision, we expressed our broader concerns about the constitutionality of the Act. Congress could have updated the coverage formula at that time, but did not do so. Its failure to act leaves us today with no choice but to declare subsection 4B unconstitutional. The formula in that section can no longer be used as a basis for subjecting jurisdictions to preclearance. Our decision in no way affects the permanent nationwide ban on racial discrimination in voting found in subsection 2. We issue no holding on subsection 5 itself, only on the coverage formula. Congress may draft another formula based on current conditions. Such a formula is an initial prerequisite to a determination that exceptional conditions still exist, justifying such an extraordinary departure from the traditional course of relations between the states and the federal government. Our country has changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions. The judgment of the Court of Appeals is reversed. Justice Thomas concurring. I join the court's opinion in full, but write separately to explain that I would find subsection 5 of the Voting Rights Act unconstitutional as well. The court's opinion sets forth the reasons. The Voting Rights Act of 1965 employed extraordinary measures to address an extraordinary problem. In the face of unremitting and ingenious defiance of citizens' constitutionally protected right to vote, subsection 5 was necessary to give effect to the 15th Amendment in particular regions of the country. Though subsection 5's preclearance requirement represented a sharp departure from basic principles of federalism and the equal sovereignty of the states, the court upheld the measure against early constitutional challenges because it was necessary at the time to address voting discrimination where it persisted on a pervasive scale. Today, our nation has changed. The conditions that originally justified subsection 5 no longer characterize voting in the covered jurisdictions. As the court explains, voter turnout and registration rates now approach parity. Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels. In spite of these improvements, however, Congress increased the already significant burdens of subsection 5. Following its reenactment in 2006, the Voting Rights Act was amended to prohibit more conduct than before. Section 5 now forbids voting challenges with any discriminatory purpose, as well as voting changes that diminish the ability of citizens on account of race, color, or language minority status to elect their preferred candidates of choice. While the pre 2006 version of the Act went well beyond protection guaranteed under the Constitution, it now goes even further. It is thus quite fitting that the Court repeatedly points out that this legislation is extraordinary and unprecedented, and recognizes the significant constitutional problems created by Congress's decision to raise the bar that covered jurisdictions must clear, even as the conditions justifying that requirement have dramatically improved. However one aggregates the data compiled by Congress, it cannot justify the considerable burdens created by subsection 5. As the Court aptly notes, no one can fairly say that the record shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that faced Congress in 1965 and that clearly distinguished the covered jurisdictions from the rest of the nation at that time. Indeed, circumstances in the covered jurisdictions can no longer be characterized as exceptional or unique. The extensive pattern of discrimination that led the court to previously uphold subsection 5 as enforcing the 15th Amendment no longer exists. Section 5 thus is unconstitutional. While the court claims to issue no holding on subsection 5 itself, its own opinion compellingly demonstrates that Congress has failed to justify current burdens with a record demonstrating current needs. By leaving the inevitable conclusion unstated, the court needlessly prolongs the demise of that provision. For the reasons stated in the court's opinion, I would find subsection 5 unconstitutional. Justice Ginsburg, with whom Justice Breyer, Justice Sotomayor, and Justice Kagan joined dissenting. In the court's view, the very success of subsection 5 of the Voting Rights Act demands its dormancy. Congress was of another mind. Recognizing that large progress has been made, Congress determined, based on the voluminous record, that the scourge of discrimination was not yet extirpated. This question this case presents is who decides whether, as currently operative, subsection 5 remains justifiable, this court or a Congress charged with the obligation to enforce the post-Civil War amendments by appropriate legislation. With overwhelming support in both houses, Congress concluded that, for two prime reasons, subsection 5 should continue in force unabated. First, continuance would facilitate completion of the impressive gains thus far made, and second, continuance would guard against backsliding. Those assessments were well within Congress's province to make and should elicit this court's unstinting approbation. Voting discrimination still exists, no one doubts that, but the court today terminates the remedy that proves to be the best suited to block that discrimination. The Voting Rights Act of 1965 has worked to combat voting discrimination where other remedies have been tried and failed. Particularly effective is the VRA's requirement of federal preclearance for all changes to voting laws in the regions of the country with the most aggravated records of rank discrimination against minority voting rights. A century after the 14th and 15th Amendments guaranteed citizens the right to vote free of discrimination on the basis of race, the blight of racial discrimination voting continued to infect the electoral process in parts of our country. Early attempts to cope with this vile infection resembled battling the Hydra. Whenever one form of voting discrimination was identified and prohibited, others sprang up in its place. This court repeatedly encountered the remarkable variety and persistence of laws disenfranchising minority citizens. To take just one example, the court in 1927 held unconstitutional a Texas law barring black voters from participating in primary elections. In 1944, the court struck down a reenacted and slightly altered version of the same law. And in 1953, the court once again confronted an attempt by Texas to circumvent the 15th Amendment by adopting yet another variant of the all-white primary. During this era, the court recognized that discrimination against minority voters was a quintessentially political problem requiring a political solution. As Justice Holmes explained, if the great mass of the white population intends to keep the blacks from voting, relief from that great political relief from that great political wrong, if done as alleged by the people of a state and the state itself, must be given by them or by the legislative and political department of the government of the United States. Congress learned from experience that laws targeting particular electoral practices or enabling case by case litigation were inadequate to the task. In the Civil Rights Acts of 1957, 1960, and 1964, Congress authorized and then expanded the power of the Attorney General to seek injunctions against public and private interferences with the right to vote on racial grounds. But circumstances reduced the ameliorative potential of these legislative acts. Voting suits are unusually onerous to prepare, sometimes requiring as many as 6,000 man-hours spent combing through registration records in preparation for trial. Litigation has been exceedingly slow, in part because of the ample opportunities for delay afforded voting officials and others involved in the proceedings. Even when favorable decisions have finally been obtained, some of the states affected have merely switched to discriminatory devices not covered by the federal decrees or have enacted difficult new tests designed to prolong the existing disparity between white and African American registration. Alternatively, certain local officials have defied and evaded court orders or have simply closed their registration offices to freeze the voting rolls. Patently, a new approach was needed. Answering that need, the Voting Rights Act became one of the most consequential, efficacious, and amply justified exercises of federal legislative power in our nation's history. Requiring federal preclearance of changes in voting laws in the covered jurisdictions, those states and localities where opposition to the Constitution's commands were most virulent, the VRA provided a fit solution for minority voters as well as for states. Under the preclearance regime established by subsection 5 of the VRA, covered jurisdictions must submit proposed changes in voting laws or procedures to the Department of Justice, which has 60 days to respond to the changes. A change will be approved unless DOJ finds it has the purpose or the effect of denying or abridging the right to vote on account of race or color. In the alternative, the covered jurisdiction may seek approval by a three-judge district court in the District of Columbia. After a century's failure to fulfill the promise of the 14th and 15th Amendments passage of the 14th and 15th Amendments, passage of the VRA finally led to signal improvement on this front. The Justice Department estimated that in the 5 years after the VRA's passage, almost as many blacks registered to vote in Alabama, Mississippi, Georgia, Louisiana, North Carolina, and South Carolina as in the entire century before 1965. And in assessing the overall effects of the VRA in 2006, Congress found that significant progress has been made in eliminating first generation barriers experienced by minority voters, including increased numbers of registered minority voters, minority voter turnout, and minority representation in Congress, state legislatures, and local elected offices. This progress is the direct result of the Voting Rights Act of 1965. On that matter of cause and effects, there can be no genuine doubt. Although the VRA wrought dramatic changes in the realization of minority voting rights, the Act to date surely has not eliminated all vestiges of discrimination against the exercise of the franchise by minority citizens. Jurisdictions covered by the preclearance requirement continued to submit in large numbers proposed changes to voting laws that the Attorney General declined to approve, auguring that auguring that barriers to minority voting would quickly resurface were the preclearance remedy eliminated. Congress also found that as the registration and voting of minority citizens increased, other measures may be resorted to which would dilute increasing minority voting strength. Efforts to reduce the impact of minority votes, in contrast to direct attempts to block access to the ballot, are aptly described as second generation barriers to minority voting. Second generation barriers come in various forms. One of the blockages is racial gerrymandering, the redrawing of legislative districts in an effort to segregate the races for purposes of voting. Another is adoption of a system of at large voting in lieu of district by district voting in a city with a sizable black minority. By switching to at-large voting, the overall majority could control the election of each city council member, effectively eliminating the potency of the minority votes. A similar effect could be achieved if the city engaged in discriminatory annexation by incorporating majority white areas into city limits, thereby decreasing the effect of VRA occasioned increases in black voting. Whatever the device employed, this court has long recognized that vote dilution, when adopted with a discriminatory purpose, cuts down the right to vote cuts down the right to vote as certainly as of access to the ballot. In response to evidence of these substituted barriers, Congress reauthorized the VRA for 5 years in 1970, for 7 years in 1975, and for 25 years in 1982. Each time, this court upheld the reauthorization as valid exercise of congressional power. As the 1982 reauthorization approached its 2007 expiration date, Congress again considered whether the VRA's preclearance mechanism remained an appropriate response to the problem of voting discrimination in covered jurisdictions. Congress did not take this task lightly. Quite the opposite. The 109th Congress that took responsibility for the renewal started early and conscientiously. In October 2005, the House began extensive hearings, which continued into November and resumed in March 2006. In April 2006, the Senate followed suit with hearings of its own. In May 2006, the bills that became the VRA's reauthorization were introduced in both houses. The House held further hearings of considerable length, as did the Senate, which continued to hold hearings into June and July. In mid July, the House considered and rejected four amendments, then passed the reauthorization by a vote of 390 yeas to 33 nays. The bill was read and debated in the Senate, where it passed by a vote of 98 to 0. President Bush signed it a week later, on July 27, 2006, recognizing the need for further work in the fight against injustice. Calling the reauthorization an example of our continued commitment to a united America where every person is valued and treated with dignity and respect. In the long course of the legislative process, Congress amassed a sizable record. The House and Senate Judiciary Committees held 21 hearings, heard from scores of witnesses, and received a number of investigative reports and other written documentation of continuing discrimination in covered jurisdictions. In all, the legislative record Congress compiled more than 15,000 pages. The compilation presents countless examples of flagrant racial discrimination since the last reauthorization. Congress also brought to light systematic evidence that intentional racial discrimination in voting remains so serious and widespread in covered jurisdictions that Section 5 preclearance is still needed. After considering the full legislative record, Congress made the following findings. The VRA has directly caused significant progress in eliminating first-generation barriers to ballot access, leading to a marked increase in minority voter registration and turnout and the number of minority elected officials. But despite this progress, second-generation barriers constructed to prevent minority voters from fully participating in the electoral process continue to exist, as well as racially polarized voting in the covered jurisdictions, which increase the political vulnerability of racial and language minorities in those jurisdictions. Extensive evidence of continued discrimination, Congress concluded, clearly showed the continued need for federal oversight in covered jurisdictions. The overall record demonstrated to the federal lawmakers that without the continuation of the Voting Rights Act of 1965 protections, racial and language minority citizens will be deprived of the opportunity to exercise their right to vote or will have their votes diluted, undermining the significant gains made by minorities in the last 40 years. Based on these findings, Congress reauthorized preclearance for another 25 years, while also undertaking to reconsider the extension after 15 years to ensure that the provision was still necessary and effective. The question before the court is whether Congress had the authority under the Constitution to act as it did. In answering this question, the court does not write on a clean slate. It is well established that Congress's judgment regarding exercise of its power to enforce the 14th and 15th Amendments warrants substantial deference. The VRA addresses the combination of race discrimination and the right to vote, which is preservative of all rights. When confronting the most constitutionally invidious form of discrimination and the most fundamental right in our democratic system, Congress's power to act is at its height. The basis for this deference is firmly rooted in both constitutional text and precedent. The 15th Amendment, which targets precisely and only racial discrimination in voting rights, states that, in this domain, Congress shall have the power to enforce this article by appropriate legislation. In choosing this language, the amendment's framers invoked Chief Justice Marshall's formulation of the scope of Congress's power under the Necessary and Proper Clause. Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution, are constitutional. It cannot tenably be maintained that the VRA, an act of Congress adopted to shield the right to vote from racial discrimination, is inconsistent with the letter or spirit of the 15th Amendment, or any provision of the Constitution read in light of the Civil War amendments. Nowhere in today's opinion or Northwest Austin is there clear recognition of the transformative effect of the 15th Amendment aimed to achieve. Notably, the founders' first successful amendment told Congress that it could make no law over a certain domain. In contrast, the Civil War amendments used language that authorized transformative new federal statutes to uproot all vestiges of unfreedom and inequality, and provided sweeping enforcement powers to enact appropriate legislation targeting state abuses. The stated purpose of the Civil War amendments was to arm Congress with the power and authority to protect all persons within the nation from violations of their rights by the states. In exercising that power, then, Congress may use all means which are appropriate, which are plainly adapted to the constitutional ends declared by these amendments. So when Congress acts to enforce the right to vote free from racial discrimination, we ask not whether Congress has chosen the means most wise, but whether Congress has rationally selected means appropriate to a legitimate end. It is not for us to review the congressional resolution of the need for its chosen remedy. It is enough that we be able to perceive a basis upon which the Congress might resolve those conflict as it did. Until today, in considering the constitutionality of the VRA, the court has accorded the Congress the full measure of respect its judgments in this domain should garner. As against the reserved powers to the states, Congress may use any rational means to effectuate the constitutional prohibition of racial discrimination in voting. Faced with subsequent reauthorizations of the VRA, the court has reaffirmed this standard. Today's court does not purport to alter settled precedent, establishing that the dispositive question is whether Congress has employed rational means. For three reasons, legislation reauthorizing an existing statute is especially likely to satisfy the minimal requirements of the rational basis test. First, when reauthorization is at issue, Congress has already assembled a legislative record justifying the initial legislation. Congress is entitled to consider that pre-existing record as well as the record before it at the time of a vote on reauthorization. This is especially true where, as here, the court has repeatedly affirmed the statute's constitutionality and Congress has adhered to the very model the court has upheld. Second, the very fact that reauthorization is necessary arises because Congress has built a temporal limitation into the act. It has pledged to review after a span of years. It has planned to review after a span of years, first 15, then 25, and in light of contemporary evidence, the continued need for the VRA. Third, a reviewing court should expect the record supporting reauthorization to be less stark than the record originally made. Demand for a record of violations equivalent to the one earlier made would expose Congress to a catch-22. If the statute was working, there would be less evidence of discrimination. So opponents might argue that Congress should not be allowed to renew the statute. In contrast, if the statute was not working, there would be plenty of evidence of discrimination, but scant reason to renew a failed regulatory regime. This is not to suggest that congressional power in this area is limitless. It is this court's responsibility to ensure that Congress has used appropriate means. The question meet for traditional review is whether the chosen means are adapted to carry out the objectives the amendments have in view. The court's role, then, is not to substitute its judgment for that of Congress, but to determine whether the legislative record sufficed to show that Congress could rationally have determined that its chosen provisions were appropriate methods. In summary, the Constitution vests broad power in Congress to protect the right to vote, and in particular, to combat racial discrimination in voting. This court has repeatedly reaffirmed Congress's prerogative to use any rational means in exercise of its power in this area, and both precedent and logic dictate that the rational means test should be easier to satisfy and the burden on the statute's challenger should be higher. When what is at issue is the reauthorization of a remedy that the court has previously affirmed and that Congress found from contemporary evidence to be working to advance the legislature's legitimate objective. The 2006 reauthorization of the Voting Rights Act fully satisfies the standards stated in McCulloch. Congress may choose any means appropriate and plainly adapted to a legitimate constitutional end. As we shall see, it is implausible to suggest otherwise. I begin with the evidence on which Congress based its decision to continue the preclearance remedy. The surest way to evaluate whether that remedy remains in order is to see if preclearance is still effectively preventing discriminatory changes to voting laws. On that score, the record before Congress was huge. In fact, Congress found that there were more DOJ objections between 1982 and 2004, 626, than there were between 1965 and 1982, 490. All told, between 1982 and 2006, DOJ objections blocked over 700 voting changes based on a determination that the changes were discriminatory. Congress found that the majority of DOJ objections included findings of discriminatory intent, and that the changes blocked by preclearance were calculated decisions to keep minority voters from fully participating in the political process. On top of that, over the same time period, DOJ and private plaintiffs succeeded in more than 100 actions to enforce the subsection 5 preclearance requirement. In addition to blocking proposed voting changes through preclearance, DOJ may request for more information from a jurisdiction proposing a change. In turn, the jurisdiction may modify or withdraw a proposed change. The number of such modifications or withdrawals provides an indication of how many discriminatory proposals are deterred without the need for formal objection. Congress received evidence that more than 800 proposals were altered or withdrawn since the last reauthorization in 1982. Congress also received empirical studies finding that DOJ's requests for more information had a significant effect on the degree to which covered jurisdictions complied with their obligation to protect minority voting rights. Congress also received evidence that litigation under subsection 2 of the VRA was an inadequate substitute for preclearance in the covered jurisdictions. Litigation occurs only after the fact when the illegal voting scheme has already been put in place and individuals have been elected pursuant to it, thereby gaining the advantage of incumbency. An illegal scheme might be in place for several election cycles before a subsection 2 plaintiff can gather sufficient evidence to challenge it. And litigation places a heavy financial burden on minority voters. Congress also received evidence that preclearance lessened the litigation burden on covered jurisdictions themselves, because the preclearance process is far less costly than defending against a subsection 2 claim, and clearance by DOJ substantially reduces the likelihood that a subsection 2 claim will be mounted. The number of discriminatory changes blocked or deterred by the preclearance requirements suggests that the state of voting rights in the covered jurisdictions would have been significantly different absent this remedy. Surveying the type of changes stopped by the preclearance procedure conveys a sense of the extent to which subsection 5 continues to protect minority voting rights. Set out below are characteristic examples of changes blocked in the years leading up to the 2006 reauthorization. In 1995, Mississippi sought to reenact a dual voter registration system, which was initially enacted in 1892 to disenfranchise black voters, and for that reason was struck down by a federal court in 1987. For the 2000 census, the city of Albany, Georgia, proposed a redistricting plan that DOJ found to be designed with the purpose to limit and retrogress the increased black voting strength in the city as a whole. In 2001, the mayor and all-white 5-member board of aldermen of Kilmichael, Mississippi, abruptly canceled the town's elections after an unprecedented number of African American candidates announced they would be running for office. DOJ required an election, and the town elected its first black mayor and three black aldermen. In 2006, this court found that Texas's attempt to redraw a congressional district to reduce the strength of Latino voters bore the mark of intentional discrimination that could give rise to an equal protection violation, and ordered the district redrawn in compliance with the VRA. In 2003, after African Americans won a majority of the seats on the school board for the first time in history, Charleston County, South Carolina proposed an at large voting mechanism for the board. The proposal, made without consulting any of the African American members of the school board, was found to be an exact replica of an earlier voting scheme that a federal court had determined violated the VRA. In 1993, the city of Millen, Georgia, proposed to delay the election in a majority black district by 2 years, leaving that district without representation on the city council, while the neighboring majority white district would have three representatives. The court then sought to move a polling place from a predominantly black neighborhood in a city to an inaccessible location in a predominantly white neighborhood outside city limits. In 2004, Waller County, Texas, threatened to prosecute two black students after they announced their intention to run for office. The county then attempted to reduce the availability of early voting in that election at polling places near a historically black university. In 1990, Dallas County, Alabama, whose county seat is the city of Selma, sought to purge its voter rolls of many black voters. DOJ rejected the purge as discriminatory, noting that it would have disqualified many citizens from voting simply because they failed to pick up or return a voter update form, when was no valid requirement that they do so. These examples, and scores more like them, fill the pages of the legislative record. The evidence was indeed sufficient to support Congress's conclusion that racial discrimination in voting is covered jurisdictions remained serious and pervasive. Congress further received evidence indicating that formal requests of the kind set out above represented only the tip of the iceberg. There was there was what one commentator described as an avalanche of case studies of voting rights violations in the covered jurisdictions, ranging from outright intimidation and violence against minority voters to more subtle forms of voting rights deprivations. This evidence gave Congress even more reason to conclude that the time had not yet come for a relaxed vigilance against the scourge of racial discrimination in voting. True, conditions in the South have impressively improved since the passage of the Voting Rights Act. Congress noted this improvement and found that the VRA was the driving force behind it. But Congress also found that voting discrimination had evolved into subtler second generation barriers, and that eliminating preclearance would risk loss of the gains that had been made. Facing such evidence, then, the court expressly rejected the argument that disparities in voter turnout and number of elected officials were the only metrics capable of justifying reauthorization of the VRA. I turn next to the evidence of which Congress based its decision to reauthorize the coverage formula in subsection 4B. Because Congress did not alter the coverage formula, the same jurisdictions previously subject to preclearance continue to be covered by this remedy. The evidence just described of preclearance's continuing efficacy in blocking constitutional violations in the covered jurisdictions itself grounded Congress's conclusion that the remedy should be retained for those jurisdictions. There is no question, moreover, that the covered jurisdictions have a unique history of problems with racial discrimination in voting. Consideration of this long history, still in living memory, was altogether appropriate. The court criticizes Congress for failing to recognize that history did not end in 1965, but the court ignores that what's past is prologue, and those who cannot remember the past are condemned to repeat it. Congress was especially mindful of the need to reinforce the gains already made and to prevent backsliding. Of particular importance, even after 40 years and thousands of discriminatory changes blocked by preclearance, conditions in the covered jurisdictions demonstrated that the formula was still justified by current needs. Congress learned of these conditions through a report known as the CAT study that looked at subsection 2 suits between 1982 and 2004 to examine the impact. Because the private right of action authorized by subsection 2 of the VRA applies nationwide, a comparison of subsection 2 lawsuits in covered and non-covered jurisdictions provides an appropriate yardstick for measuring differences between covered and non-covered jurisdictions. If differences in the risk of voting discrimination between covered and non-covered jurisdictions had disappeared, one would expect that the rate of successful subsection 2 lawsuits would be roughly the same in both areas. The study's finding, however, indicates that racial discrimination in voting remains concentrated in the jurisdictions singled out for preclearance. Although covered jurisdictions account for less than 25% of the country's population, the CAT study revealed that they accounted for 56% of successful subsection 2 litigation since 1982. Impact and effectiveness 1974. Controlling for population, there were nearly 4 times as many successful subsection 2 cases in covered jurisdictions as there were non-covered jurisdictions. The CAT study further found that subsection 2 lawsuits are more likely to succeed when they are filed in covered jurisdictions than in non-covered jurisdictions. From these findings, ignored by the court, Congress reasonably concluded that the coverage formula continues to identify the jurisdictions of greatest concern. The evidence before Congress, furthermore, indicates that voting in the covered jurisdictions was more racially polarized than elsewhere in the country. While racially polarized voting alone does not signal a constitutional violation, it is a factor that increases the vulnerability of racial minorities to discriminatory changes in voting law. The reason is twofold. First, racially polarized voting means that racial minorities are at risk of being systematically outvoted and have their interests underrepresented in legislatures. Second, when political preferences fall along racial lines, the natural inclination of incumbents and ruling parties to entrench themselves have predictable racial effects. Under circumstances of severe racial polarization, efforts to gain political advantage translate into race-specific disadvantages. In other words, a governing political coalition has an incentive to prevent changes in the existing balance of voting power. When voting is racially polarized, efforts by the ruling party to pursue that incentive will inevitably discriminate against a racial group. Just as buildings in California have a greater need to be earthquake-proofed, places where there is greater racial polarization in voting have a greater need for prophylactic measures to prevent purposeful racial discrimination. This point was understood by Congress and is well recognized in the academic literature. The case for retaining a coverage formula that met needs on the ground was therefore solid. Congress might have been charged with rigidity had it afforded covered jurisdictions no way out, had it afforded covered jurisdictions no way out, or ignored jurisdictions that needed superintendents. Congress, however, responded to this concern. Critical components of the congressional design are the statutory provisions allowing jurisdictions to bail out of preclearance and for court-ordered bail-ins. The VRA permits a jurisdiction to bail out by showing that it has complied with the Act for 10 years and has engaged in efforts to eliminate intimidation and harassment of voters. It also authorizes a court to subject a non-covered jurisdiction to federal preclearance upon finding that violations of the 14th and 15th Amendment have occurred there. Congress was satisfied that the VRA's bailout mechanism provided an effective means to adjusting the VRA's coverage over time. The success of the bailout illustrates that 1. Coverage status is neither permanent nor overbroad, and 2. Coverage status has been and continues to be within the control of the jurisdiction, such that those jurisdictions that have a genuinely clean record and want to terminate coverage have the ability to do so. Nearly 200 jurisdictions have successfully bailed out of the preclearance requirement, and DOJ has consented to every bailout application filed by an eligible jurisdiction since the current bailout procedure became effective in 1984. The bail-in mechanism has also worked. Several jurisdictions have been subject to federal preclearance by court orders, including the states of New Mexico and Arkansas. This experience exposes the inaccuracy of the court's portrayal of the act as static, unchanged since 1965. Congress designed the VRA to be a dynamic statute, capable of adjusting to changing conditions. True, many covered jurisdictions have not been able to bail out due to recent acts of noncompliance with the VRA, but that truth reinforces the congressional judgment that these jurisdictions were rightfully subject to preclearance and ought to remain under that regime. Congress approached the 2006 reauthorization of the VRA with great care and seriousness. The same cannot be said of the court's opinion today. The court makes no genuine attempt to engage with the massive legislative record that Congress assembled. Instead, it relies on increases in registration and turnout as if that were the whole story. Without ever identifying a standard of review, the court dismissively brushes off arguments based on data from the record and declines to enter the debate about what the record shows. One would expect more from an opinion striking at the heart of the nation's signal piece of civil rights legislation. I note the most disturbing lapses. First, by what right, given its usual restraint, does the court even address Shelby County's facial challenge to the VRA? Second, the court veers away from controlling precedent regarding the equal sovereignty doctrine without even acknowledging that it is doing so. Third, hardly showing the respect ordinarily paid when Congress acts to implement the Civil War amendments, and as just stressed, the court does not even deign to grapple with the legislative record. Shelby County launched a purely facial challenge to the VRA's 2006 reauthorization. A facial challenge to a legislative act, the court has other times said, is of course the most difficult challenge to mount successfully, since the challenger must establish that no set of circumstances exists under which the act would be valid. Under our constitutional system, courts are not roving commissions assigned to pass judgment on the validity of the nation's laws. Instead, the judicial power is limited to deciding particular cases and controversies. Embedded in the traditional rules governing constitutional adjudication is the principle that a person to whom a statute may constitutionally be applied will not be heard to challenge that statute on the ground that it may be conceivably be applied unconstitutionally to others in other situations not yet before the court. Yet the court's opinion in this case contains not a word explaining why Congress lacks the power to subject to preclearance the particular plaintiff that initiates this lawsuit, Shelby County, Alabama. The reason for the court's silence is apparent, for as applied to the Shelby County, the VRA's preclearance requirement is hardly contestable. Alabama is home to Selma, site of the Bloody Sunday beatings of civil rights demonstrators that served as the catalyst for the VRA's enactment. Following those events, Martin Luther King Jr. led a march from Selma to Montgomery, Alabama's capital, where he called for passage of the VRA. If the act passed, he foresaw progress could be made even in Alabama, but there had to be a steadfast national commitment to see the task through to completion. In King's words, the arc of the moral universe is long, but it bends towards justice. History has proved King right. Although circumstances in Alabama have changed, serious concerns remain. Between 1982 and 2005, Alabama had one of the highest rates of successful subsection 2 suits, second only to its VRA-covered neighbor, Mississippi. In other words, even while subject to the restraining effect of subsection 5, Alabama was found to have denied or abridged voting rights on account of race or color more frequently than nearly all other states of the Union. This fact prompted the dissenting judge below to concede that a more narrowly tailored coverage formula, capturing Alabama and a handful of other jurisdictions with an established track record of racial discrimination in voting, might be defensible. That is an understatement. Alabama's sorry history of subsection 2's violations alone provides sufficient justification for Congress's determination in 2006 that the state should remain subject to subsection 5's preclearance requirement. A few examples suffice to demonstrate that, at least in Alabama, the current burdens imposed by subsection 5's preclearance requirement are justified by current needs. In the interim between the VRA's 1982 and 2006 reauthorizations, this court twice confronted purposeful racial discrimination in Alabama. In Pleasant Grove v. United States, the court held that Pleasant Grove, a city in Jefferson County, Shelby County's neighbor, engaged in purposeful discrimination by annexing all white areas while rejecting the annexation request of an adjacent black neighborhood. The city had shown unambiguous opposition to racial integration both before and after the passage of the federal civil rights laws, and its strategic annexations appeared to be an attempt to provide for the growth of a monolithic white voting bloc for impermissible purpose of minimizing future black voting strength. 2 years before Pleasant Grove, the court in Hunter v. Underwood struck down a provision of the Alabama Constitution that prohibited individuals convicted of misdemeanor offenses involving moral turpitude from voting. The provision violated the 14th Amendment's Equal Protection Clause, the court unanimously concluded, because its original enactment was motivated by a desire to discriminate against blacks on account of race, and the provision continues to this day to have that effect. Pleasant Grove and Hunter were not anomalies. In 1986, a federal district judge concluded that the at-large election system in several Alabama counties violated subsection 2. Summarizing its findings, the court stated that from the late 1800s through the present, Alabama has consistently erected barriers to keep black persons from full and equal participation in the social, economic, and political life of the state. The Dillard litigation ultimately expanded to include 183 cities, counties, and school boards employing discriminatory at-large election systems. One of those defendants was Shelby County, which eventually signed a consent decree to resolve the claims against it. Although the Dillard litigation resulted in overhauls of numerous electoral systems tainted by racial discrimination, concerns about backsliding persist. In 2008, for example, the city of Calera, located in Shelby County, requested pre-clearance of a redistricting plan that would have eliminated the city's sole majority black district, which had been created pursuant to the consent decree in Dillard. Although DOJ objected to the plan, Calera forged ahead with elections based on unpre-cleared voting changes, resulting in the defeat of the incumbent African American councilman who represented the former majority black district. The city's defiance required DOJ to bring a subsection 5 enforcement action that ultimately yielded appropriate redress, including restoration of the majority black district. A recent Federal Bureau of investigation provides a further window into the persistence of racial discrimination in state politics. Recording devices worn by state legislatures cooperating with the FBI's investigation captured conversations between members of the state legislature and their political allies. The recorded conversations are shocking. Members of the state Senate derisively referred to African Americans as aborigines and talk openly about their aim to quash a particular gambling-related referendum because the referendum, if placed on the ballot, might increase African American voter turnout. These conversations occurred not in the 1870s or even the 1960s. They took place in 2010. The district judge presided over the criminal trial at which the recorded conversations were introduced, commented that the recordings represent compelling evidence that political exclusion through racism remains a real and enduring problem in Alabama. Racist sentiments, the judge observed, remain regrettably entrenched in the high echelons of state government. These recent episodes forcibly demonstrate that subsection 5's pre-clearance requirement is constitutional as applied to Alabama and its political subdivisions. And under our case law, that conclusion should suffice to resolve this case. This court has consistently rejected constitutional challenges to legislation enacted pursuant to Congress's enforcement powers under the Civil War amendments upon finding that the legislation was constitutional as applied to the particular set of circumstances before the court. A similar approach is warranted here. The VRA's exceptionally broad severability provision makes it particularly inappropriate for the court to allow Shelby County to mount a facial challenge to subsections 4B and 5 of the VRA, even though application of these provisions to the county falls well within the bounds of Congress's legislative authority. The severability provision states, if any provision of this act or the application thereof to any person or circumstance is held invalid, the remainder of the act and the application of the provision to the other persons not similarly situated or to other circumstances shall not be affected thereby. In other words, even if VRA could not constitutionally be applied to certain states, for example, Arizona and Alaska, subsection 1973P calls for those unconstitutional applications to be severed, leaving the act in place for jurisdictions as to which its application does not transgress constitutional limits. Nevertheless, the court suggests that limiting the jurisdictional scope of the VRA in an appropriate case would be to try our hand at updating the statute. Just last term, however, the court rejected this very argument when addressing a materially identical severability provision, explaining that such a provision is Congress's explicit textual instruction to leave unaffected the remainder of the Act if any particular application is unconstitutional. Leaping to resolve Shelby County's facial challenge without considering whether application of the VRA to Shelby County is constitutional or even addressing the VRA's severability provision, the court's opinion can hardly be described as an exemplar or of restrained or and moderate decision making. Quite the opposite. Hubris is a fit word for today's demolition of the VRA. The court stops any application of subsection 5 by holding that 4B's coverage formula is unconstitutional. It pins this result in large part to the fundamental principle of equal sovereignty. In Katzenbach, however, the court held, in no uncertain terms, that the principle applies only to terms upon which states are admitted to the Union and not to the remedies for local evils which have subsequently appeared. Katzenbach, the court acknowledges, rejected the notion that the equal sovereignty principle operates as a bar on different treatment outside the context of admission of new states. But the court clouds that once clear understanding by citing dictum from Northwest Austin to convey that the principle of equal sovereignty remains highly pertinent in assessing subsequent disparate treatment of states. If the court is suggesting that dictum in Northwest Austin silently overruled Katzenbach's limitation of the equal sovereignty doctrine to the admission of new states, the suggestion is untenable. Northwest Austin cited Katzenbach's holding in the course of declining to decide whether the VRA is constitutional or even what standard of review applied to the question. In today's decision, the court ratchets up what was pure dictum in Northwest Austin, attributing breadth to the equal sovereignty principle in flat contradiction of Katzenbach. The court does so by with nary an explanation of why it finds Katzenbach wrong, let alone any discussion of whether stare decisis nonetheless counsels adherence to Katzenbach's ruling on the limited significance of the equal sovereignty principle. Today's unprecedented extension of the equal sovereignty principle outside its proper domain, the admission of new states, is capable of much mischief. Federal statutes that treat states disparately are hardly novelties. Do such provisions remain safe given the court's expansive expansion of equal sovereignty's sway? Of gravest concern, Congress relied on our path-marking Katzenbach decision in each reauthorization of the VRA. It had every reason to believe that the Act's limited geographical scope would weigh in favor of, not against, the Act's constitutionality. Congress could hardly have foreseen that the VRA's limited geographic reach would render the Act constitutionally suspect. In the court's conception, it appears, defenders of the VRA could not prevail upon showing what the record overwhelmingly bears out, i.e., that there is a need for continuing the preclearance regime in covered states. In addition, the defenders would have to disprove the existence of a comparable need elsewhere. I am aware of no precedent for imposing such a double burden on defenders of legislation. The court has time and again declined to upset legislation of this genre unless there is unless there was no or almost no evidence of unconstitutional action by states. No such claim can be made about the congressional record from the 2006 VRA reauthorization. Given a record replete with examples of denial or abridgment of a paramount federal right, the court should have left the matter where it belongs, in Congress's bailiwick. Instead, the court strikes subsection 4B's coverage provision because, in its view, the provision is not based on current conditions. It discounts, however, that one such condition was the preclearance remedy in place in the covered jurisdictions, a remedy designed both to catch discrimination before it causes harm and to guard against return to old ways. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. But the court insists that but the court insists the coverage formula is no good. It is based on decades-old data and eradicated practices. Even if the legislative record shows, as engaging with it would reveal, that the formula accurately identifies the jurisdictions with the worst conditions of voting discrimination, that is of no moment, as the court sees it. Congress, the court decrees, must start from scratch. I do not see why that should be so. Congress's chore was different in 1965 than it was in 2006. In 1965, there was a small number of states, which in most instances were familiar to Congress by name, on which Congress fixed its attention. In drafting the coverage formula, Congress began work with reliable evidence of actual voting discrimination in a great majority of the states it sought to target. The formula Congress eventually evolved to describe these areas also captured a few states that had not been subject of congressional fact finding. Nevertheless, the court upheld the formula in its entirety, finding it fair to infer a significant danger of evil in all places the formula covered. The situation Congress faced in 2006 when it took up reauthorization of the coverage formula was not the same. By then, the formula had been in effect for many years, and all the jurisdictions covered by it were familiar to Congress by name. The question before Congress was there still a sufficient basis to support continued application of the preclearance remedy in each of those already identified places? There was at that point no chance that the formula might inadvertently sweep in new areas that were not the subject of congressional findings, and Congress could determine from the record whether the jurisdictions captured by the coverage formula still belonged under the preclearance regime. If they did, there was no need to alter the formula. That is why the court, in addressing prior reauthorizations of the VRA, did not question the continuing relevance of the formula. Consider once again the components of the record before Congress in 2006. The coverage provision identified a known list of places with an undisputed history of serious problems with racial discrimination in voting. Recent evidence relating to Alabama and its counties was there for all to see. Multiple Supreme Court decisions that had upheld the coverage provision, most recently in 1999, there was extensive evidence that, due to the preclearance mechanism, conditions in the covered jurisdictions had notably improved. And there was evidence that preclearance was still having a substantial real world effect, having stopped hundreds of discriminatory voting changes in the covered jurisdictions since the last reauthorization. In addition, there was evidence that racial polarization in voting was higher in covered jurisdictions than elsewhere, increasing the vulnerability of minority citizens in those jurisdictions. And countless witnesses, reports, and case studies documented continuing problems with voting discrimination in those jurisdictions. In light of this record, Congress had more than a reasonable basis to conclude that the existing coverage formula was not out of sync with conditions on the ground in covered areas. And certainly Shelby County was no candidate for release through the mechanism Congress provided. The court holds that subsection 4B is invalid on the ground that it is irrational to base coverage on the use of voting tests 40 years ago, when such tests have been illegal since that time. But the court disregards what Congress set about to do in enacting the VRA. That extraordinary legislation scarcely stopped at the particular tests and devices that happened to exist in 1965. The grand aim of the act is to secure to all in our polity equal citizenship stature, a voice in our democracy undiluted by race. As the record for 2000, as the record for the 2006 reauthorization makes abundantly clear, second-generation barriers to minority voting rights have emerged in the covered jurisdictions as attempted substitutes for the first-generation voting barriers that originally triggered preclearance in those jurisdictions. The sad irony of today's decision lies in its utter failure to grasp why the VRA has proved effective. The court appears to believe that the VRA's success in eliminating the specific devices extant in 1965 means that preclearance is no longer needed. With that belief and the argument derived from it, history repeats itself. The same assumption that the problem could be solved when particular methods of voting discrimination are identified and eliminated was indulged and proved wrong repeatedly prior to the VRA's enactment. Unlike prior statutes, which singled out particular tests or devices, the VRA is grounded in Congress's recognition of the variety and persistence of measures designed to impair minority voting rights. In truth, the evolution of voting discrimination into more subtle second-generation barriers is powerful evidence that a remedy as effective as preclearance remains vital to protect minority voting rights and prevent backsliding. Beyond question, the VRA is no ordinary legislation. It is extraordinary because Congress embarked on a mission long delayed and of extraordinary importance to realize the purpose and promise of the 15th Amendment. For a half century, a concerted effort has been made to end racial discrimination in voting. Thanks to the VRA, progress once the subject of a dream has been achieved and continues to be made. The record supporting the 2006 reauthorization of the VRA is also extraordinary. It was described by the chairman of the House Judiciary Committee as one of the most extensive considerations of any piece of legislation that the United States Congress has dealt with in the 27 and a half years he had served in the House. After exhaustive evidence gathering and deliberative process, Congress reauthorized the VRA, including the coverage provision, with overwhelmingly bipartisan support. It was the judgment of Congress that 40 years has not been a sufficient amount of time to eliminate the vestiges of discrimination following nearly 100 years of disregard for the dictates of the 15th Amendment, and to ensure that the right of all citizens to vote is protected as guaranteed by the Constitution. That determination of the body empowered to enforce the Civil War amendments by appropriate legislation merits this court's utmost respect. In my judgment, the court errs egregiously by overriding Congress's decision. For the reasons stated, I would affirm the judgment of the Court of Appeals. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop it in the comments and I'd be happy to take a look. Thank you.